appeal in the matter of Alton and Powszechny Zaklad Ubezpieczen SA.
Yes, Mr. McCrimmon.
May it please your lordships, I appear on behalf of the appellant, and my learned friend Mr. Prentice, assisted by Mr. Austin, appears on behalf of the respondent.
Yes.
My lord, this matter comes before you as a second appeal from the decision of His Honour Judge Parker against his order made on the 21st of July 2023. My lord, in terms of how I intend to take things, I intend to deal with the relevant factual background and then focus my attention on the first ground of appeal, thereafter taking the second ground of appeal. My lords, I hope that you've had the opportunity to consider the skeleton arguments that have been lodged by both.
We have, thank you.
My lord, in terms of the relevant facts, it's perhaps as well just to understand the key actors in this case. And what I mean by that is who different entities are. So the appellant is a Polish insurance company who provided cover to the at-fault vehicle in respect of this accident. Into Europe RG are the UK claims representatives that represent the appellant in respect of any claims that are made against them in this jurisdiction. My lord, in terms of the facts, this is a road traffic accident that occurred as long ago as the 12th of September 2017 between junctions 1 and 2 on the M20 motorway. The claim was issued on the 17th of September 2017, initially being brought against Into Europe RG incorrectly. A defence to that claim was put in on the 2nd of March 2021, and I'd be grateful if your lordships would turn to the defence.
Happy to do that, but in a sense, I think, have a pretty firm grip on the sequence of events. If it's important that we actually see it in black and white, then we're very happy to go there. But you put up a couple of bars as you saw it. One of them was cured and one of them wasn't. In your defence.
That's just so, my lord. My lord, in terms of what I wanted to demonstrate to you was the extent to which the defendant took the trouble to set out the issue that now troubles this court.
Well, I don't think there's any, there's no dispute that by the time you got to the Deputy District Judge on your strikeout, that one of these matters had not been put right. And indeed, a formal application to amend wasn't issued until 6 months after the hearing before the Deputy District Judge in respect of the uncorrected matter.
Very well, my lord. My lord, I take it from that it won't assist you if I delve much further.
I don't want to close down, but in a sense, I don't think anything turns on the detail of it, or that your instructing solicitors or whoever it was who actually dealt with the pleading set out in black and white what they needed to do.
Thank you,
but
my lord.
Underlying this, as I understand it, is that this is a case in which liability was not an issue. It was a small or smallish claim, and these essentially were matters of relative formality. I think that's the substantial point that we're going to need to come to in due course, as to whether there was really anything very serious underlying the poorly pleaded claim.
Very well.
Because at some point, not now but later, we're going to have to stand back and say, what's going on in these proceedings? They've been going on for a very long time, accumulating costs, nothing actually happening by way of progress. And if the case is not struck out, how we might have to proceed. But let's go back to where you were and take us forward through the chronology.
I'm grateful, my lord. My lord, in terms of the chronology, I've taken you to the defence date. Thereafter, we have two applications that are made, oddly enough, on the same date independently of one another. We have the claimant's application to amend to deal with the naming issue, the issue that your lordship has noted has been addressed, and then the defendant's application, first application to strike out,
Yes.
that made an application for strike out on the basis that the naming was defective and on the cause of issue.
So there's that's 12th of April 2020.
That's right, my lord. My lord, in terms of the claimant's application, that came before Deputy District Judge Murphy. Deputy District Judge Murphy made an order on the 23rd of April 21 in which he granted, or 22 rather, he granted permission to amend the name of the defendant. It appears, for reasons unknown and I can't explain to the court, the defendant's application didn't at the same time come before either Deputy District Judge Murphy or another judge. It was subsequently sent out to the County Court at Dartford for listing. And
would the order of Deputy District Judge Murphy to have been box work?
It appears to be.
Yeah.
There was no hearing, my lord, and it was expressed that the application was to be without notice.
Yep.
My lord, in terms of the defendant's application, I've already addressed you that that was sent out for listing at the County Court at Dartford. When it arrived there, Deputy District Judge Roffey considered that application and noted, seemingly, Deputy District Judge Murphy's earlier order disposing of the claimant's application, and he ordered that the matter be listed for the 15th of March 22 to deal only with wasted costs issues flowing from the amendment. My lord, that explains why a further application of the 5th of January 23 was made by the defendant. I apologise, 22 was made by the defendant.
I'm sorry.
What explains it?
That's the fact that Deputy District Judge Roffey confined the defendant's application for strikeout just to consider the issue of wasted costs of the amendment, because he noted that the amendment to the name had been, or she had noted that the amendment to the name had been dealt with, and assumed, it appears, that that was dispositive of the application made by the defendant.
Yeah, well, it was, because that application was made by Inter-Europe. Once PZU had been substituted, if PZU wanted to make an application, it would have to make its own application. Is that right?
Just so, my lord.
So that's what the 5th of January application really needed to do.
It's to put it on a proper footing that the defendant now set out in these proceedings, the appellant makes the application to strike out.
In fact, I think the 5th of January application still names Inter-Europe as the defendant, and strictly speaking, was another application by Inter-Europe, not as it should have been, and I think as it was treated as being, as an application by PZU. So perhaps a slip by those on your side, but one I think which was treated as unimportant, because it was treated as an application by PZU.
That's got to be right, my lord, and the reason why I say that with such boldness is that we have, and your lordship's called out for these yesterday, and that's why I've handed in printed copies this morning, the skeletons that were before Deputy District Judge Pithouse at the 10th of March, application hearing 22, and your lordship notes, just when I pick up at random the claimant skeleton that was before him, you see that the case title reflects that the defendant is PZU. You'll forgive me, my lord, that I don't attempt the pronunciation of the defendant's name. My lord, in terms of the application on the 5th of January 22, I've already indicated that that came on for hearing before Deputy District Judge Pithouse on the 10th of March 2022. And at that hearing, your lordships know that Deputy District Judge Pithouse struck out the claim. That order itself was appealed to His Honour Judge Parker, sitting in the Dartford County Court, and he allowed the claimant's appeal on the 21st of July 23. In terms of chronology, my lords, that's all I say, unless there are matters that you wish me to.
Can I ask a question? Sorry to interrupt.
No,
We
my lord.
have in the bundle tab 6, a chronology. Is it agreed between the parties?
Yes.
Thank you.
Thank you, my lord, I'm grateful. So, my lords, with that, may I address you in terms of ground 1 of this appeal, and that is that. Is it-
Just before we get into that, could I just satisfy myself about one matter, which is to pick up the order of Judge Parker, which is at
44.
page 44 in the bundle. Paragraph 2 refers to a number of matters which are set aside for a hearing of 2.5 hours before a different judge. Could we just tie in to the narrative that you've given us what is happening here, that subject to this appeal, of course, would happen next? What are the moving parts of this that further need to be decided before this small claim can make any progress?
My lord, if you are against me on the appeal,
Of course, it's
I know,
hypothetical. I just want to understand what the judge thought
yes.
was happening.
quite, my lord, if you're against me on this appeal, and then His Honour Judge Parker's order stands, the intention is that there will be a further hearing, as Your Honour, as my lord properly notes, by CVP, listed for 2.5 hours, so that the application to amend can be considered.
That's A.
At A, and thereafter, if that fails, the claimant's application to strike out will be considered.
Right. So B is contingent upon the failure of A.
My lord, it has to be. You know?
And that's how it works. I see. It hadn't clicked in my mind what was being meant here.
Yes.
It's nothing to do with wasted costs from a previous from the previous order by DJ Roffey.
Well, that's to be considered as C, as my lord notes, and I would just draw your attention, if I may, to 44. The application to pay wasted costs will then be considered.
That's into Europe's application.
I wonder.
Well, it's got to be into Europe's application. I'll put it this way, my lord. If
Oh, I see. Or contingently PZUs as well.
Yes.
quite,
Yes,
my
I see,
lord.
that's
So
exactly.
do you see the way it works?
It's into Europe's anyway, which was not dealt with, and it's contingently
Well, it's not.
PZUs if.
I'm not sure it's entirely clear that it's still into Europe's or I mean the wasted costs.
I think the discussion at the end of the hearing before
That it
Judge
picked that
Parker
up to do.
picked that up and indicated that was also to deal with what hadn't been dealt with as a result.
So we
of
should
Judge
read.
Roffey's
Yeah,
order.
we should read C as being in relation to the old issue of wasted costs of Inter Europe, plus any wasted costs that might arise if the application to amend was not successful.
That's right.
That was what it would have said, long form.
I follow. Thank you.
Okay, that's very helpful. I now understand paragraph 2,
Thank you.
and now you're coming to the ground.
Thank you, my lord. My lord, in terms of ground one, it's said on behalf of the appellant that His Honour Judge Parker was wrong in law in finding that the Deputy District Judge was wrong to strike out the respondent's claim. My lord, I deal at paragraph 14 and I place myself in your hands to some degree with the case law that deals with the meaning of essentially what is plainly wrong for the purposes of an appeal court, such as His Honour Judge Parker looking at and reviewing Deputy District Judge Pithouse's decision. Would your lordships be assisted if I take you to the authorities?
Can we clarify in our minds before we consider the ground on its merits? Under ground one, is your case essentially that on the facts as you've described them, the Deputy District Judge was perfectly entitled to strike out this claim?
That's my case.
And ground one is really to do with the Deputy District Judge's ambit of the exercise of his powers, and you're seeking to persuade us, although the judge was not persuaded, that the judge, Deputy District Judge, is entitled to act in the way that he did, and therefore the judge had no business to be interfering.
Just so, my lord.
Right. So that's ground one, and I think you can take it that an argument of that sort, namely the degree to which an appeal court is acting properly in interfering with an evaluative exercise of that kind, needs little elaboration for us, because it's obviously a principle that binds us as much as it does any other appeal judge. And this was, in deciding about the strikeout, this was an evaluative exercise being carried out by the Deputy District Judge.
That's right, my lord.
So if that's the focus of ground one, then in a sense the well-known authorities about judicial restraint in this area are very well known to us.
I'm grateful, my lord, and for that, on the basis of that indication, I won't address you more fully on the authorities. My lord,
But sorry, just to follow that through, if ground one does not succeed, and we were to conclude that this was a case where the judge was entitled to interfere, then would the consequence be that that Judge Parker had to make his own mind up as a matter of evaluative assessment? And do I understand that your ground two is a challenge to his evaluative assessment on the assumption that you don't succeed on ground one? If you succeed on ground one, you say you need go no further. If you fail on ground one, you say, is this right? On ground two, well, Judge Parker got it wrong.
my lord, it's a combination of the two in my submission. One has to look at what Deputy District Judge Pithouse found in relation to the primary facts on the first application, and also look at what His Honour Judge Parker's conclusions were, having heard the appeal.
I'm not sure I'm following that. If Judge Parker was entitled to interfere under the well-known principles, then the question arises as to whether we are entitled to interfere with his evaluative assessment. Is that right or not?
That's right, my lord.
And are you saying that in looking at his evaluative assessment, he was bound by some findings of fact such that he couldn't make his own mind up about those? I'm just not quite understanding how your argument works.
My lord, in terms of the argument, what I say is this: in terms of what material, and we'll come on to look at So Kim in a moment, what material was before Deputy District Judge Pithouse. He's limited in my submission. His Honour Judge Parker is limited to consideration of that material, and that appears to be consistent with how the appeal unfolded, and your lordships have a full transcript of that.
Yes, I think we'll probably come back to this, but I flagged that at the moment there seem to me to be two quite distinct matters along the lines of the observations made by my lord. The first being your ground one, which we have clear in mind, which was that the circuit judge had no business on your case to be interfering with the exercise of discretion by the original judge.
That's right.
And that's quite clear. But if, contrary to your argument, he was entitled to interfere, then at that point there would be various things that he could do. He could either say, well, I'm going to remit this to the district judge, another district judge, to be done again, but that might not be very realistic because it's very poor use of resource. Or he's saying, I'm going to decide this myself. And then he has an evaluative role to play. Now, I understand you to be saying that in that evaluative role, he has to act upon the facts as known to the deputy district judge. Is that your argument?
The material.
Well, why should that be so? That if he's deciding the matter for himself, is he not entitled to decide it at the point in time of his decision, or do you say he has to throw his mind back to the previous year?
My lord, I'll listen very carefully to what my learned friend says, but my understanding is the way the appeal unfolded in front of His Honour Judge Parker is thus that he was looking at the material that was before Deputy District Judge Pithouse in any event.
To test this proposition, that in fact by that stage an application to amend had been made, because it was made between the first and the second decisions, but the judge did not focus on that. He focused on the original situation.
I think he didn't even have that material, is that right?
Well,
he didn't have that application or the supporting witness statement.
My understanding, my lord, from reading the transcript, I didn't appear below, and I want to make that absolutely clear to the court, is that it was His Honour Judge Parker that alerted the parties to the application. And my lord, just to go further in respect of the material that's relevant to ground two, I just go back, my lord, if I may, to the order at page 44, where His Honour, and I just draw your attention, if I may, to primary paragraph 2, where he makes it clear that it's not to be listed before him, and clearly that's because he may have reached some provisional view, but he reached no concluded view in my submission.
Well, we've got an issue then which we'll keep in sight, which is on what material was the judge entitled to act when he was, and in fact what material did he act upon when he was making his own decision. But ultimately we have to decide, don't we, whether if he was on firm ground in making a fresh decision about this application to strike out, whether the decision he came to was within the range of decisions that he was entitled to make.
Yes, my lord.
So the focus of ground one is on the deputy district judge, and the focus of ground two is on the circuit judge.
That's right, my lord.
Good. Well, that's been helpful to me at least. Thank you.
Thank you, my lord. Dealing with ground one, in terms of His Honour Judge Parker, his criticism can be found of Deputy District Judge Pithouse's decision can be found at page 53. And it's paragraph 35, my lords, where His Honour Judge Parker focused on the issue of proportionality and the decision in Kim and So Young. Kim So Young. In terms of the challenge to that, my lord, my submission is that there was too much focus by His Honour Judge Parker on the issue of whether the respondent should be given an opportunity, a further opportunity, to address matters by way of an amendment.
Can I ask a question, please? Was it a relevant consideration? You say giving too much focus is inappropriate, but was it a relevant consideration?
It was a relevant consideration, but in terms of proportionality, a whole range of matters arise, my lord. It's not just simply the loss of the claim to the respondent. One has to have regard to delay and other matters, expense. My lord quite properly has identified some of those matters this morning.
Thank you.
My lords, it's my submission that Deputy District Judge Pithouse had the issue of proportionality well in mind, and he noted it this way. And by reference to his judgment, if I could take you to page 114, please.
Just before we do that, do we take it from the previous page, which identifies this as a transcript for approval, that this isn't a transcript which he has had the opportunity to, or at least has approved or considered? It's just is a recording of what he said on the occasion.
My lord, that's my understanding. I haven't been told that His Honour Judge Parker has considered.
No. Whether the Deputy District
Judge
I
apologise.
has had an opportunity to approve the transcript, and as one, I speak for myself, often does, because I don't speak prose, tidied it up to express it in language that might be more felicitous.
My lord, it does say, and I draw your attention if I may, to 115, it's at the bottom,
Oh, it says
that this transcript has been approved by the judge.
The words
Thank
for
you.
approval, I think, appear in all the transcripts that we receive, and sometimes I forget to delete them.
Yes. Thank you very much. So it was approved by the judge. Thank you.
My lord, and in terms of the issue of proportionality, I draw your attention to these matters, if I may. Paragraph 2, where Deputy District Judge Pithouse identifies that a previous application has been made to amend to substitute the current defendant. Secondly, he's noted at paragraph 8 that the pleading before him remained deficient. And you see what he says there. He doesn't criticise counsel who then appeared for the respondent, but he considered that there needed to be a resolution to certain matters.
So just taking it in stages, paragraph 8 really addresses 2 points, does it? One, this is an issue that's already been flagged up, and 2, at the moment, there hasn't been an issued application. Those are the two. Those are the 2 points that are there being made. Thank you.
And in respect of the third matter, I draw your attention, if I may, to paragraph 10. Paragraph 10.
Forgive me, can I just ask you to pause on paragraph 9? Paragraph 9 refers to the Limitation Act, and should we read that as him saying an application will have to address a Limitation Act point without really expressing a view as to how that might or might not affect it?
That's the only way in which that can be understood, my lord.
Yes, thank you. Yes, and then you were going to take us to paragraph 10.
Paragraph 10 notes that there is some prevarication on the part of the respondent in terms of what follows next, and you see that there's some surprise expressed by the Deputy District Judge that there's no firm route map, if I can put it like that, as to how the claim proceeds. And he expresses some surprise in that regard. And in terms of delay, this is the fourth point, in terms of delay, he makes clear that he's fixed in his mind the issue of delay with this claim, where he says, obviously that is, and I emphasise, my lords, another 2 months that have gone by. And what he's talking about there is the period between the defendant's application to strike out,
Second strikeout application in January
second strike,
and the hearing in March.
That's right, my lord.
Can you just help me? Is there a Limitation Act 2017?
My lord, no. That's got to be a reference to a Limitation Act 1980.
It's the Section 32 point, whether it arises out
Yeah.
of the same or substantially the same facts. But
Yes, I was just wondering where 2017 came from.
I think, I don't mean to be rude, but I think my lord might mean Section 35, which is the genesis for
Section 35
For
for Part
Rule
17.
17 and 4.2.
Quite right. Section 35.
I point out at paragraph 10 that Deputy District Judge Pithouse is keeping well in mind the delay that is going on in this claim. And I draw your attention back to paragraph 2, where we have a situation where there's an application in April, as I've told you in setting out the chronology, 12th of April 21, to rectify one matter.
The point that you're addressing here, as I understand it, is the circuit judge's key point is that there wasn't really any assessment of the proportionality of the strikeout, which is an exercise that would require some sort of consideration of the effects for or against the making of a strikeout. Now, it clearly, look at what I'm not quite sure how any of the paragraphs you've so far mentioned amounts to any sort of what one might call in jargon proportionality evaluation. You've pointed out that the judge referred more than once to the issue of delay. Perhaps it's in his very first paragraph that he puts something on the other side of the scale, which he just said he's reluctant to take away the rights of individuals who feel they have in some way been in a position where they may well be entitled to some form of compensation. But I mean, actually in this case, as I understood it, subject to proof of loss, there wasn't any issue about liability. There was an issue about whether they were suing the right person or in the right manner, but on the face of it, this was somebody who was likely to be entitled to at least some compensation, subject to proof. And so at the moment, but you have the opportunity to say otherwise, it seems to me that that paragraph at the beginning is the only reflection of some factor that might speak against striking out a claim that, even if it had been incompetently presented, was otherwise a perfectly straightforward and valid claim. Is there any other reflection of that side of the matter in the district judge's evaluation?
My lord, paragraph 12, he deals with the fact that that he wasn't satisfied that there was sufficient pleading.
Yes, I'm talking about, I mean, on the face of it, I mean, you know, poor Miss Alton isn't responsible for any of this shambles. You know, she just got run into. You know, for years, this has been going on without making any progress. Surely one of the matters that any judge seeking to apply the overriding objective would have in mind is whether what's happened is so contrary to the administration of justice in an efficient manner, that she should be deprived of what, on the face of it, she's entitled to. Is there anywhere else in the judgment, apart from the throat clearing in paragraph 1, where there's any attempt to conduct that exercise?
My lord, my submission is this, that one has to read the judgment as a composite.
Yes.
And paragraph 1 deals with the fact that Deputy District Judge Pithouse acted with some hesitation, and he had in mind the fact that the course that he was taking would be to deprive the claimant of her claim. But my submission is that read as a whole, he felt able to do that because there was no, as I said to my lord a moment ago, route map to take him forward to give directions for the claim to proceed.
Would you dispute the fact that on the face of it, this was a claimant who is entitled to at least some compensation for personal injury, and that the defect in the pleading was, to put it bluntly, a technical defect, or arguably a technical defect?
It's a technical defect, my lord. Of course, breach of duty, and you've seen a fully pleaded defence, concedes the issue of breach of duty, leaves live issues of causation and issues of quantification of damage. I don't demur from the fact that this is a technicality in terms of pleading, but my lord, the point is this. Part 16 is very clear. One has to plead your case properly, and if you don't plead your case properly, there are powers given to the courts pursuant to their case management powers, and I have in mind, in particular, Civil Procedure Rule 3.4, where the court can strike out that claim. And my lords, I say that when you read this judgment in a composite way, in the way that I've taken you through, you see that Deputy District Judge Pithouse is looking for, and I go back to this phraseology that I've adopted, a route map. He's looking for a way to deal with matters. He's positively, in my respectful submission, keeping in mind the loss of the claim to the claimant at paragraph 10. He doesn't expressly say it, my lord, and I've got to be clear about that. But you see how he opens paragraph 10. I am surprised. There is peppered throughout this judgment a sense of frustration on the part of the Deputy District Judge, but he feels, in my respectful submission, when you read this judgment as a whole, he has no other option but to strike out the claim, particularly when it's not clear to him, and it wasn't clearly put to him, that the claimant would make an application.
Sorry. Well, I may be maybe the same point, but I mean, when you say no other option, what about an unless order?
My lord, there was no viable option available to the judge.
It seems that getting struck out finally stimulated the claimant's advisors into putting in an application some months later to amend. Why as a district judge would one not say, fine, you've got, it could be 7 days, you've got 2 weeks, you've got a month, but this is your last chance to get your tackle in order. Why is that not an option in this situation?
Because in my submission, my lord, and this is why I've addressed you on it in detail, the delay was so egregious that he wasn't prepared.
Delay since when?
Delay right through proceedings. I say, my lord, that by identifying at paragraph 2, he was keeping in mind that the claimant had already attempted a resolution of one issue.
So delay since the defence is what you're talking about here.
That's right, my lord. And my lord, when I addressed you in opening in terms of the facts, I said to you that the only thing I'd take you to the defence for was to show how fully pleaded it was.
Yes, so you're not talking about the delay since January, you're talking about the delay since year before that.
That's right, my lord. My lord, my submission is that read as a composite, the Deputy District Judge is taking the totality of the delay into account. And I say that I'm sure-footed in that by reference again to the well-known paragraph 10, and it's 4 lines from the bottom, where he, and I lay emphasis on it, another.
Yeah, but forgive me, I'm sure I'm being slow. You said the delay is so egregious and didn't complete the sentence. Are you submitting to us that the delay, the judge found the delay was so egregious that it was incapable of being cured? That was enough in itself to justify strikeout. If you are saying that, where did he say that in paragraph 10?
No, my lord, I'm not. Coupled,
Because in paragraph 10 he contemplates an application being made.
the egregious nature of the delay is coupled with the fact that there was no way forward. And if I could draw your attention, my lords, to the skeleton argument, which is the height of the argument that was put before Deputy District Judge Pithouse, and it's the skeleton argument of the claimant. You might have it in loose leaf. We see it at paragraph 17, which is the height of the claimant's case before Deputy District Judge Pithouse. We see that there's an assertion that the claim is capable of amendment. There's discussion of Article 18 of Rome 2, which allows one to rely on the law of the insurance contract in which to pursue a direct right of action against a civil liability insurer. My lords, it should be clear, Brexit doesn't affect this issue. Your lordships are probably already there, but I make that point, and so it's clear. And then in B, there's a rather woolly reference in my respectful submission to the fact that there is the 6th Motor Insurance Directive that gives an instruction to member states to put in place a direct right of action. There's no assertion.
Sorry, what's woolly about that?
Well, it's woolly this way, my lord. We don't have identified by the claimant the piece of legislation that is said to have been produced in Poland to comply with the directive, the 6th Motor Insurance Directive. So
that I understand. It doesn't identify the particular provision of Polish law which gave effect to that.
that's right.
Directive. But what was said in argument was, well, it was Poland's obligation to give effect to the directive, and therefore it's overwhelmingly likely that it did. And your clients are Polish insurers, and one would expect them, when they saw a skeleton of this case, to come back and say, if it were the case, oh, well, no, Poland hasn't done that. Wouldn't one? They would know.
Well, my lord, with respect, the obligation in terms of pleading and proof is on the claimant in my submission. It's the claimant to identify the material upon which the claimant relies to say that she can properly advance an amendment.
Well, I'll come back to that, if I may, in a moment. But just on the way it was put, it was, we haven't identified the provision of Polish law, but it's overwhelmingly likely that there is one. And the only response to that was, oh, but there'll be a limitation point in relation to the pleading. It wasn't that, no, there's no direct claim against an insurer under Polish law. So that so far as the DDJ was concerned, would he have been entitled, indeed bound, to assume that there was at the lowest a good arguable case, that there was a direct claim against the insurer under Rome 2?
Is that His Honour Judge Parker?
No, the Deputy District Judge. These are the skeletons, as I understand
Yes.
it, before the Deputy District Judge, in which this, paragraph 17, this basis for a direct claim had been set out. And although, as you point out, it doesn't go on to say, here's the provision of Polish law which gave effect to the directive, would the Deputy District Judge have been entitled or indeed bound to proceed on the basis that that was overwhelmingly likely to be the case, such that there was a pleadable direct claim against the insurer?
My lord, I'll apologise immediately. When I heard you first time, I thought you said DCJ, and that's why I clarified as to who.
If I did, that's my fault.
No.
DDJ.
It's just so you know why I responded in that way. I wasn't trying to avoid your question. In terms of the Deputy District Judge, in my submission, he wasn't bound to take the low bar that Poland would comply with their obligations to put in place a direct right of action pursuant to the direction from Article 18 of the 6th Motor.
I don't understand what you mean by the low bar.
That he has.
What does that
He wouldn't.
mean?
He wouldn't have been able to assume at the very lowest, my lord, that Poland would have complied with their obligations.
But I think my lord's point arises in this way, that with very proper clarity, your defence pleaded two admitted defects in the claim against you. And that was very appropriate for, instead of, as it were, lying low and taking, trying to ambush somebody or something of that sort, you pointed out this won't do in its current form. And you said two things, but you didn't say a third thing, which is it wouldn't matter how you amended because it could never be us, PZU. And so surely the court in this country, bearing in mind that it's dealing with a Polish entity, or institutional entity, is likely to draw an inference that silence in that respect is telling. I think that's the reasoning here. Not that, and I appreciate for your clients very irksome to have to do all the work of both parties in a claim of this kind, but nevertheless, the fact you didn't plead that there was actually a fundamental difficulty here, but in fact a technical difficulty, means that the district judge ought to have approached matters on the basis that this was technical.
My lord, in terms of pleading a positive averment that there was no direct right of action, I say that obligation didn't arise on the defendant. The defendant pleads to the case that's presented. And if this court is going to say, in this case, or by way of general guidance, that one has to plead to every possible issue that might arise, then...
I don't think that was, I concede the difficulty of any such statement. I don't think that's quite the point that was being made here. It was a question of what situation the district judge found himself in, and what the real issues were for him to decide in order to decide issues for strikeout, issues against strikeout, and the significance of the fact that there had been no application yet made to amend.
Very well.
That's helpful. Thank you.
As I say, in my submission, the defendant wasn't under a duty to start making any assertion, and my lord, I do point out that this skeleton argument was dated one day before the hearing, so to make those enquiries. And remember, I would ask my lord to remember, and your lordships to remember, that the claims handling agent acts on behalf of the appellant, and so will not have all of the knowledge of the appellant, and will need to take instructions in a normal way. And my lord, I don't go too far, but sometimes getting instructions quickly from a foreign insurer is not easy, and I think that's as far as I can take it.
Can I just ask you about something else about paragraph 10? The second half of it addresses the 2-month delay. I understand that, and but the first half expresses surprise that the claimants are considering whether they ought to apply to the court to amend, and you treat that as as the Deputy District Judge recognising that they were prevaricating, as you put it in your skeleton. They still hadn't said, they not only didn't have an application to amend, but they still weren't saying whether they were going to or not. And the point that's put against you in relation to that, as I understand it, is that it's perfectly obvious from this skeleton argument and the reference to an unless order, that they indicated that they did want to make the amendment, and they were inviting the court to say, you can be sure that we're going to, because you can make an unless order, that if we don't make one, then it can be struck out. So what was the Deputy District Judge wrong to treat them as you've characterised it, as prevaricating?
Well, my lord, in terms of that, I turn to paragraph 18 of the skeleton argument that we've just been looking at. It doesn't identify more than this, that the claimant can make an application and ought to be permitted to make an application. It doesn't say that the claimant will make an application.
How could the suggestion of an unless order have been consistent with prevaricating?
Because, my lord, I say that paragraph 18 on a proper reading just allows the claimant more time to consider matters, and my submission is that the Deputy District Judge wasn't prepared to grant more time to consider matters because he considered that there had been time enough. And I come back to this issue of delay.
What is what's wrong with paragraph 18 of Mr. Rowley's document that leads the judge at paragraph 12 to say he wasn't satisfied that there is sufficient pleading that would enable this matter to overcome the requirements and the contents of pleading? What was the deputy not obliged to grapple with the fact that he'd been told that these matters were capable of amendment and could be amended?
Well, my lord, if there's going to be proper reliance on So Kim, then he should have looked for material. And if I can, my lord, can I turn now to So Kim? Because I think this might be an opportune time to look at So Kim.
Just before you do, I said I'd come back to the question that your submission, that it was for the claimant to plead and prove the entitlement under foreign law.
That's right.
And is there any room here for the principle that foreign law is presumed to be the same as English law if there is insufficient evidence about it? Suppose, for example, that everything that was said in paragraph 17 had been put in a pleading, in a draft amendment, as opposed to just being put forward orally, and had been the subject matter of an application. And I understand what you say about that not being the case, but I think you also made the point, well, this is woolly because it doesn't identify the relevant provision of Polish law. And I was just wondering whether it would need to. Suppose that the pleading said nothing more than paragraph 17, and didn't try and identify the relevant Polish domestic implementation. Would the claimant be entitled to say, well, foreign law is presumed to be the same as English law under the third limb of the Dicey test, and irrespective of the directive being the background, we can presume that Polish law provides, as English law provides, that there is a direct claim against the insurer in relation to the insurance of drivers of vehicles that are based in or registered in its domestic territory.
My lord, if you're going to apply the presumption of similarity, then in my submission you have to take all of the facets of English law, all of the matters that English law set out in order for a direct right of action to arise. So we're squarely then back, my lord, to the European Community's Rights Against Insurers Regulations 2002. And if we're saying that we're assuming Polish law is the same or similar, then we're back to those regulations. And my lord, we're confronted with the same issues that we have in respect of bringing the claim under the 2002 regulations in the first place, namely that the vehicle, and this is not in dispute, the vehicle bore a Polish registration plate. So by reference to Article Regulation 2.2 of the European Community's Rights Against Insurers 2002 regulations was treated as normally based in Poland, whereas Regulation 2.1 of those regulations defines a vehicle as a term of art and requires that a vehicle is normally based in the United Kingdom.
Yes, so English law is that for vehicles that are based here, presumptively that's where they're registered, there is a direct right of action.
That's right, Michael.
But Polish law, might it be presumed, would provide the same in relation to vehicles based in, registered in Poland.
My
Of
lord,
course, that would be the same as English law.
my lord,
Domestically registered vehicles which are involved in accidents and which are insured give rise to a direct right against the insurer.
my lord, I think we differ this way. I say that if you're relying on the presumption of similarity, you've got to take the whole of the English law that you're presuming is the same, which, and I don't want to repeat myself, I refer to the 2002 regulations. So you can't modify the 2002 regulations.
So are you saying that if you apply the presumption, it would assume that in Poland there is a similar law which applies to vehicles registered in the UK?
That's right, my lord.
Yes,
It gives rise to a nonsense. But if I can put it, if I can put it this way, my lord, it's rather this. It's all or nothing.
It would mean that wherever one had a directive within the EC requiring individual member states in the single market to introduce the same laws, you could only apply that presumption in the way you've just described, not just for this case, but more generally.
My lord, it may be that some member states, and we're not considering other member states.
Could I just ask a question? The skeleton says this is a directive in 2009.
Yes, my lord.
Most directives have a date by which each member state is required to comply. Sometimes 2 or 3 years, sometimes a bit longer. If a member state fails to comply, the Commission normally takes infraction proceedings. Isn't it stretching credulity to think that by the time this came before the district judge, this issue hadn't been resolved to the knowledge of PZU one way or the other?
Well, my lord, that would be a...
And your client knows the answer.
My lord, that would be a very proper argument. The difficulty with that argument, my lord, is this, and I'm sorry that it's not before you. I can arrange for it to be before you. But the 2002 regulations give effect to the 5th Motor Insurance Directive. They've never been updated by the United Kingdom to reflect the 6th Motor Insurance Directive. And of course, that again, it is not a matter that's affected by Brexit in terms of whether the Commission take action, because your Lordship has noted that the regulation is dated in 2009. Insofar as I'm aware, and I'll be corrected by my learned friend, I'm sure, if I'm wrong, there have been no proceedings taken against the United Kingdom.
Well, that may very well be because the regulations complied with the 6th directive as well as the 5th directive. That doesn't mean they're not compliant.
My lord, there are works, Robert Meakin in particular, Law of Insurance, Law of Motor Insurance, that indicates that they are deficient and they don't comply with the 6th Motor Insurance. And my lords, I've already offered, if your lordships would find it helpful, I can place material before you that deals with that. Of course, I didn't know that was going to arise until my lord's perfect.
Yes, but my question is about the position in Poland, which was the matter which was being put before the Deputy District Judge. And we have the skeleton from the defendant, which, I don't know, it isn't dated, but there it is.
You've answered my question about presumption. Thank you. Thank you very much.
My lord,
I wanted to raise it.
My lord, I know you didn't raise this specifically, but can I deal with this in terms of the way that one pleads foreign law? Because there was I detected from you that it might be just enough to say that the direct right of action arises in Polish law and insert a full stop and close the book, that be the end of the matter. My Lord, I say it's not, and we have a very clear direction on that from the Supreme Court in the judgment of Lord Legate in the Bramley 2 litigation, if I can summarise it as the Bramley 2.
Yes, FS Carrow number 2. Yeah.
And it's paragraph 165, where his lordship is very clear that one can't just plead rather nebulously that in that case the law of Egypt provided for something. One has to set out the specific rules and provisions. So that fortifies my argument in my submission that what should have been done by the claimant was to identify the specific rule, article, whatever of the Polish code I think we see in the bundle before us to be relied upon. And absent that, the Deputy District Judge was right in my respectful submission, not drawing any inferences, not least because of the position that we find ourselves in the UK, being in default of a directive and no action resulting.
Are you going to take us to Sue Kim?
Yes, my lord.
Thank
My lord, in terms of Sue Kim, you find that in the appellant's bundle, starting properly, my lord, at page 32. My lord, so that the court can understand the decision, you see at paragraph 1 that this is a libel action.
Completely different set of circumstances.
It is, my lord, but it's helpful to see the facts in action, because I say it gives you an indication here. It's a libel action against 4 defendants, and you see at paragraph 8, just over leaf, that there were arguments being made by the claimant that articles written about him suggested that he was abusing his position as a blackmailer, a fraudster, and the like, and I go no further. And at paragraph 22 of that decision, we see, and I'd invite your lordships to read this, we see that the defendant's solicitor wrote to the claimant to say, your pleadings aren't up to scratch here because you've not said...
Stuff went out on the internet, but they didn't identify the people who had specifically read it.
My lord is familiar with the case. And at paragraph 25, page 35 of the authorities bundle, you see that there was an application to strike out the claim on that basis, that there was a deficiency. What happened, this, and my lord, knowing the decision as you do, will probably know that this was a litigant in person representing himself. He didn't put any material before the master to identify people who might have read the words complained of. But after the hearing, you see this at paragraph 30, he wrote to the master saying that he could get such evidence. And then, furthermore, at paragraph 32, after the draft judgment was sent to him, he sent 13 witness statements to the master. And the master in that case, Master K, said it was much too late and proceeded on the basis of the information that he'd received in the hearing. My lord, in terms of what followed from that, paragraph 39, you see that Mr. Justice Tugendhat, who heard the appeal, considered that the master had taken a too restrictive approach. And at paragraph 40 on page 38, you see paragraph 40, which was a matter referred to at the appeal below. My lords, can I invite you to read paragraph 40?
Yes. So I was just putting in order the sequence of events, which there was a hearing on the 18th of November, and immediately following the hearing, the 13 witness statements came in, and the strikeout was on the 20th of January.
That's right, my lord.
So that was the sequencing in that case. So we're at paragraph 40.
My lords, if you read paragraph 40, I would draw to your attention that although it says that it would be normal for the court to refrain striking out and giving an opportunity to the party concerned to put right the defect, that's not unqualified, and it's qualified this way by the words, provided that there is reason to believe that he will be in a position to put right the defect. And I say that that's the difficulty for the respondent on this appeal, based on the material that I've taken you to, namely the skeleton argument of her counsel at the hearing before Deputy District Judge
So in the Kim case, the claimant had already done it, hadn't just said that they would do it or might do it, they'd done it.
That's right.
Well, they hadn't actually done it, but they had said at the hearing, we can cure this defect because we've got all these witness statements. Didn't identify them, but said actually to Master K, there are all these individuals who have read it and we've got witness statements from them. That's what's recorded, I think, in paragraph 30.
And then
This
30.
judgment and paragraph 19 of the Master's judgment. And you say that's different from the case we're considering because the Deputy District Judge didn't have sufficiently identified to him how the defect could be cured. Is that right?
That's right. And you see at paragraph 40 that Mr. Justice Tugendhat, towards the end of that paragraph, says that the claimant demonstrated that this was not wishful thinking or a bluff. In my submission, I'm not saying that the respondent was bluffing in front of the Deputy District Judge, but there was no material upon which the Deputy District Judge could get his teeth into to understand that this was any more than wishful thinking on the part of the respondent. So he was entitled, in my submission, absent.
So when you say this was any more than wishful thinking, the ability to cure the defect by an amendment.
That's right, my lord.
Thank you.
There was nothing that was before him, and I won't rehearse, my lords, what I've said about the difficulties with the material that's before him. But my basic and primary submission is that that material, paragraphs 17 and 18 of the respondent's counsel's skeleton argument, was insufficient for all the reasons set out in my skeleton, expanded upon orally. My lords, my submission in respect of the Deputy District Judge's conclusions and going back to his judgment, he was entitled to reach the conclusion that the pleading was, well, there are 4 points that I made. He was entitled to find that the pleading was insufficient. He was entitled to find
The existing pleading.
the existing pleading
Yes.
was deficient.
That was common ground.
Common ground. He was entitled to find that there was no, and I'll stick with the phraseology I employed up until this point, route map to cure matters. He was entitled to find, in my submission, thirdly, that there was significant delay. And fourthly, he was entitled to find that the claimant had had an opportunity previously, by references paragraph 2, to remedy the defect. So, my lord, for all those reasons,
And is it your submission that those findings, which you say he was entitled to make, were sufficient without consideration of anything else to support his decision?
well, my lord, those matters go squarely to the issue of proportionality, and in particular have regard to, if this court approves the statement at paragraph 40 of Sue Kim, as regard to the relevant matters. Not expressed, and I'm bound to concede in the tidiest way, and I think the questioning about the approval of the transcript was getting at the point, had the judge had an opportunity to tidy matters up and to address things, do a little bit of fine tuning. But all those matters are squarely relevant in my submission to the issue of proportionality and what he needed to require under the principle in paragraph 40 of Sue Kim.
Right. So is that ground one?
My lord, can I just check?
Yes.
And my lord, finally, I just draw your attention to paragraph 21 of my skeleton argument, page 26 of the bundle. And my lord, I reinforce those points that are made there regarding the previous opportunities, the lack of conviction in presenting.
These really fall under ground two, don't they? As I mean, of course, as you say, there's some read across, but those are not matters are not going to be forgotten if we
Very well.
arrive at ground two.
My lord, in terms of ground two, we've already dealt with the Socum case, and I deal with that, as you see, at paragraph 22 of my skeleton argument. And my primary submission is that His Honour Judge Parker applied Sue Kim in a way such as to normalise and automatically give an opportunity to a party to amend. And if I can take you please to page 53 of the appeal bundle. Paragraph 35. His Lordship, His Honour Judge Parker said that it would be, and this is the ending of that paragraph, it would be normal for the court to give a party a chance to put matters right. What His Honour didn't go on to do in my submission was deal with the second part of paragraph 40 that required the court to identify the material from which it draws its belief that the respondent would be in a position to put the defect right. And my lords, to save time, I make the same points that I've already made in regard to the material that was before His Honour Judge Parker. he had the same material as Deputy District Judge Pithouse in terms of the material he relied upon. He relied upon the notion that there would be an application or potential application. He relied, in other words, my lords, on paragraphs 17 and 18 of Respondent's Counsel's skeleton that was before Deputy District Judge Pithouse, and the material contained there. There was no new material in my respectful submission.
Could we perhaps enumerate, when we're considering the point that you well make, which is it's not just to do with putting the defect right, but one must have reason to believe that the defect will be put right. What are the matters that you say the judge ought, I'm talking about Judge Parker, ought to have considered as showing that they would or might not be in a position to put the defect right?
My lord, he would have needed, in my respectful submission, identification of the specific piece of Polish law relied upon.
Right, so that's further to that, a commitment to make an application to amend.
A positive commitment, but in my submission, that's very much a secondary consideration, because primarily, unless he has the specific, and I'm sorry to
No, I understand that. So
I'm sorry to keep making the point,
Mm.
but unless he's got the piece of Polish law or reference to the piece of Polish law from which the direct right of action flows.
isn't it of some importance as to what the relative significance of the identification of the precise piece of Polish law is? I mean, if in reality it's simply a question of telling the court what powers it's going to be acting under, rather than identifying whether there are any powers at all, is that not a matter of significance in deciding how to respond to a strikeout?
My lord, with the greatest respect, I maintain my primary position that he needs to know what the specific piece of Polish law is to be able to reach the conclusion that there's reason to believe that what the respondent in this case could have put the defect right.
So if it's in a sense, I don't say this demeaningly, but that it's in a sense a legal knowledge test. How would that work if the individual, as might very well be the case for this sort of claim, was unrepresented? I mean, is the court to approach matters differently? Namely, the solicitors should jolly well have got on and done their homework on this. But one might take a different view to somebody who was not legally literate.
My lord, in my submission, the court would have to make some allowance for a litigant in person, but still then, in my submission, if...
They'd still have to get the right answer in relation to provisions of Polish law.
Well, they would, my lord, because...
Okay, well, I'm just trying to see what because that, as you put it, in a sense, is your lead-off point in relation to the court's reason to believe that they would or wouldn't be able to do it.
It is right, and I just remind my lord, and I cited it, but I don't intend to take the court to it, because it seems to me that it's not contentious between my learned friend and I that matters of foreign law call for expert evidence to deal with the content of foreign law. It's treated as a peculiar kind of fact, and so it may seem to your lordship somewhat harsh that a litigant in person would have to identify those matters, but they would have to identify the foreign law provisions.
Can I ask you quite what we mean in this context by curing a defect in a pleading? a matter is properly pleaded, or an amendment is allowed if what is alleged has a real prospect of success. You don't have to show it's bound to succeed. You don't have to show it's necessarily right. It's a relatively low merits threshold, similar to that in summary judgment applications. Is that right?
My lord, that's got to be right, and you see that that's what I say in my scared silence. I can't move from that position.
So when we're talking about whether this pleading, the defect in this pleading, could be remedied, and what either the Deputy District Judge or the Circuit Judge could probably have assessed, they wouldn't have needed to be satisfied that what was said on Miss Alston's behalf, namely that it was overwhelmingly likely that there was a relevant provision of Polish law, the defect in the pleading was remediable if they were satisfied that a case with a real prospect of success to that effect could be put forward. Is that the right way of looking at it?
My lord, yes, but one couldn't be satisfied that there was a real prospect of success without reference to the particular provision of Polish law, because as my lord correctly identified, without that provision, one's back to the presumption of similarity. And I hope that my lord is clear that my position is that one has to take all of the law that you say is similar, and it comes to the conclusion that we're back to the 2002 regulation.
Leave aside any question of a presumption applying. Could the Circuit Judge and indeed the Deputy District Judge have been able to or required to proceed on the basis that, although it was not necessarily the case that Poland would have implemented the sixth directive, there was at least a real prospect that it had, just because it was obliged to do so? Would that have been an appropriate line of reasoning?
My lord, my submission is that because it engages foreign law, specific evidence is required. And I go further. My submission is that expert evidence would have been required. If you're against me on that point, I say it as a very minimum, the text of the provision said to be relied upon would have had to have been provided, and we're talking here about His Honour Judge Parker. He would have had to see that provision. So I see where my lord is going, but I say that this is a special type of case because of the engagement of foreign law and the way in which this court and the Supreme Court have said that we must treat foreign law. And I put that, and I don't demur from this, I put that as my central pillar. So whilst my lords might have thought this an easy case if it was wholly domestic, and perhaps one that would not have troubled this court, the reason why we're troubling this court is because of the engagement of foreign law. So I hope that's clear to my lords. If that's not clear, I'm happy to.
So in every case where a driver of a foreign registered car is insured abroad, the court must expect expert evidence.
If, my lord, the claimant in such an action is to base his claim on a direct basis as against the insurer through the conduit of Article 18 of Rome 2, then absent an admission from the defendant, that is what is expected, my lord.
Yes, exactly. You won't need the expert evidence if there's no dispute about the existence of the provision in Polish law. But we're in this position because that hasn't been pleaded yet. But in practical terms, there's a difference here, isn't there, between the arguability issue, which my lord has been asking about, as opposed to the effect of a strikeout, which prevents the arguability from even being considered. And if we got to an application for leave to amend, whether or not the Polish provision was identified by a litigant in person in a pleading, the defendant would be in a position to say there is no such Polish provision.
My lord, the first point to make, and I'm sure my lord has it well in mind, we don't deal with the litigant in person in
I
this case.
appreciate that, but we're looking at more widely.
But my lord, in terms of the arguability aspect, in order for it to be properly arguable, because it engages foreign law, my central point is that one needs to receive evidence as to the foreign law. We're in
the pleading stage, right?
well, that would be wholly consistent. My argument would be wholly consistent in my respectful submission with what Lord Legate said about the need to plead. And my lords, and I'm sure my learned friend won't object to this course, I refer to paragraph 165 of his judgment because it's so well trodden for those that deal or have anything to do with foreign law matters. It's the specifics. And that's, as I said a moment ago, what makes this case one in which the claimant, the respondent, should have gone further.
So you're saying is if the strikeout hadn't have happened, the pleading to be given leave to amend in due consistent with that authority in the Supreme Court would actually need to at that stage identify the particular provision in Poland.
That's right, my lord. To itself survive strikeout.
Or even to obtain leave to amend.
That's right, my lord. But just sticking with, imagine that I'm wrong and you're right, that it's arguable and you get your permission. If you don't put in reference to the specific article, regulation or section, then you're in real difficulty.
So every time in this country someone has a personal injury claim involving a foreign vehicle where they would want to rely upon the Rome Convention regulation, they will have to plead the particular provision in the appropriate jurisdiction overseas.
Yes, my lord. It would be the Rome 2 regulation. If you're relying,
plus also the domestic legislation abroad, giving effect to the directive.
If that exists.
Yes.
Because there are some European countries, and my lord, I don't stray too far away, but there are some European countries where they've had long-standing direct rights of action. Immediately spring to mind France and Spain, that long before there was any notion that a directive would create a direct right of action, they already had them in their system of law. And perhaps that explains why we find it in the European system. But my lord, to be absolutely clear, the central or the centrality of foreign law cannot be underestimated in this case in terms of looking at what has a real or reasonable prospect of success, whichever way one characterises it, in order to be more than merely arguable. And I think that's what, my lord, the test you were referring to, the Swain and Hillman test, one has to have regard to the specifics of the foreign law that you're relying on. That wasn't before His Honour Judge Parker, and with the very greatest of respect to His Honour Judge Parker, he didn't have the material on which he could make the finding that the defect could be put right. And as I've drawn to your attention, there's concern from the appellant's side that reading paragraph 35 at page 53 of his judgment, that he's keeping in mind the whole of the test that he's applying. It's the appellant's submission that reading that paragraph, he's lost sight of the Sue Kim test, with the greatest of respect to His Honour. He's lost sight of it, and he might be thinking about limb 1, if I can call it that, my lords, but he's lost sight of limb 2, and there's no way, without expert evidence as to Polish law, or at its lowest, at its very lowest, the provision of Polish law that the claimant intends to rely upon, he can reach a conclusion.
Would it be relevant to a consideration of whether the defect could be cured in this case that a claims handler had, before the litigation was commenced, said that liability would not be an issue?
My lord, in my submission, it would still require the claimant, and this is the way this matter's proceeded below, would require the claimant to plead the direct right of action.
I understand that, but would it not suggest that was something which the insurers had already recognised could be done?
My lord, in my submission, it would still require the claimant to say how there's liability, in the same way that in a domestic case that's put against, say, and I take at random, an insurer, Aviva Insurance Limited, one sees regulation, the 2002 regulation, which I've much referred to, pleaded, even where there's an admission of liability, because it sure-foots the claim to set out how the motor insurer, Aviva in my example, is liable to the claimant.
Could you help with this? You very kindly provided yesterday and today the skeleton arguments that were before the deputy.
Yes, my lord.
And in our bundle, we have the skeleton argument that was before the judge from the claimant. But we have another copy there of the one-page skeleton argument that was before the deputy. But I think there's one document which I think we're missing, which is...
Well, unless it was the same one that was put in before the judge. Was there a separate skeleton put in before the judge, or was the reliance on the one that you've helpfully provided yesterday, which was the one that was before the Deputy District Judge?
My lord, I have assumed that it was the same skeleton from reading the transcript, but I may not be right about that. If I could turn my back, my lord, I'm sure I could get the answer. Just check. Please forgive me, your lordships. My lords, I apologise, but there is a separate skeleton argument. I wonder if
How many pages does it run to?
it runs to 6 pages, but 5 really substantive pages.
Well, I think it's only fair to everybody that we have a full run of these documents. So would it be easily possible for that to be sent to my clerk or to somebody else's clerk at least, with a request that it's
Yes.
printed and brought to us? Thank you very much. So we'll gather it in during the course of the next few moments.
And that'll replace page 105, which at the moment
is out of place.
is said to be the document that was before the judge on the first appeal, but you've told us wasn't.
I apologise to
So
your
we can pick this up
lordships.
later perhaps, but on the first appeal, well, I'm looking here at paragraph 1, sub 2 of the single page which we've been given, the issue of foreign law being pleaded and proven is brought in as an aspect of limitation.
Yes, my lord.
That's how it was deployed before the deputy.
Yes, my lord.
Right. Good.
It was deployed that way, but in terms of looking at that provision without an extant application, it with the greatest
Yes,
respect to my learned friend who drafted
yet
it.
applied to amend.
Yes, my lord.
Right. So we're still with the judge on and your ground 2.
Yes, my lord. My lord, I made it plain that in that his honour didn't have sufficient material to allow him to have reason to believe that the respondent would be in a position to put the defect.
And the
right.
2 things that you rely on there are the no identification of the point of the aspect of Polish law that was relied upon, still less any expert opinion upon it, and the absence of any positive commitment to amend.
That's right, my lord.
Are there any other matters in that list that you would rely upon?
My lord, I rely upon my general, not attack, but explanation at paragraph 29 of my skeleton argument, page 29 of Sue Kim. I think it's accepted that it's not authority for proposition that endless opportunities will be given. But in my submission, the learned judge, His Honour Judge Parker, didn't give sufficient weight to the fact that there was the earlier application of the 12th of April 2021 when the claimant set right the defect with the name. That was the proper place to deal with all matters, especially having regard to the very fully pleaded defence. And my lords, I would take you to the defence just so you can be clear how fully the matters were pleaded. It's page 117 in the bundle before you. Sorry, 118 in the bundle before you. There's the front sheet of the defence, so you know the document that I'm referring you to. Can I take you over leave to 119, which identifies the preliminary point in terms of cause of action? My lords, I'm not going to go through each and every aspect, but you see there that, as my lord said, in the course of this appeal, this is not exactly something that's been hidden away. It's been fully pleaded, and all of the issues there are set out quite properly, flowing from paragraphs 4 and then running over leave to 120 at paragraph 11. So it's surprising, and there's no explanation in my submission as to why action wasn't taken on behalf of the respondent at the time of the earlier application. And in my submission, His Honour Judge Parker didn't give sufficient weight to the fact that this was a missed opportunity. My lords, I rely paragraphs 30 onwards on what is in essence what we've discussed regarding the merits threshold, whether one would get permission to appeal. So I don't seek to take you to what is a general principle, because those general principles we have dealt with in the course of submissions, i.e. that we have to have a particularised case. But my lords, if I can assist with anything from paragraph 30 onwards of my skeleton argument, I will. But my basic premise is that this isn't, with the greatest of respect to my lord's notion at the start of this appeal, a formality. It's not a formality, my lord. And the reason why it's not a formality is the answer that I gave in the course of the appeal. Part 16 serves a function, and one has to plead one's case properly.
I don't think, I think the expression that you agreed with was that the defect in the pleading was technical.
It's technical, but nonetheless, my lord, one has to plead matters properly. It's just like in a personal injury action, you could plead the accident, but if you don't plead causation, then if it goes to trial absent any application to amend, you're not going to succeed. That in itself, my lord, could be viewed as a technicality, but that it follows, my lord, if you're with me. My lords, I don't know whether I can assist you further. I'm happy to do so.
No, Mr. Crewe, that's been interesting and helpful. Thank you very much.
Thank you, my lord.
Yes. Mr. Patience.
Yes, my lord. I'm in your hands as to how I can assist you best, but it's my intention to grapple with the two main factual assertions made by the appellant. The first, namely, that there's no intention at the hearing in front of Deputy District Judge Pithouse, no positive intention to amend. And the second, the issue we've been traversing as to the fact of Polish law and how far that needs to be formed so that Deputy District Judge Pithouse or His Honour Judge Parker can satisfy the test in Sue Kim, namely that there's reason to believe there'd be grounds to amend the pleading. If that pleases your lords, I will deal with first the assertion which runs through my learned friend's submissions and his skeleton argument that there's no route map, there's no real intention by the claimant at the hearing in front of Deputy District Judge Pithouse as to amend full stop. A point made several times by my learned friend in his skeleton argument, paragraph page 28, page 25. The point made that all the claimant says is he might amend the pleadings and there's a lack of conviction. And that point amplified today. Put bluntly, the claimant simply does not accept that that is a fact we can safely come to on the evidence we have before us. His Honour Judge Parker certainly didn't come to that conclusion. And it won't surprise you to hear that the respondent in this appeal agrees with His Honour Judge Parker's analysis. We can see at page 50 of the bundle which deals with his judgment on the issue. At paragraph 10, His Honour Judge Parker finds, having looked at all of the documents we've been looking at today, the claimant appellant further argued that the court should consider whether the defect in its statement of case might be cured by amendment before striking out the claim, and cited the High Court decision of Park and Kim, and then sets out the relevant part. Paragraph 12, His Honour Judge Parker repeats, the appellant in this case argued before the Deputy District Judge that an amendment would cure the defect, and then at the end of that paragraph, and I say this is crucial, it was conceded that an unless order might be appropriate to ensure that this was done. It smacks of absurdity for the appellant defendant to say today that there can be no intention of the claimant to make an amendment to this statement of case in front of Deputy District Judge Pithouse, when what Mr. Rowley is saying in writing and orally, as found by His Honour Judge Parker here, and no challenge to that finding before us today, I will amend this and give me a date by which to do so.
But did Judge Parker have any more to go on than we've got to go on, which is essentially paragraph 17 and 18 of the skeleton argument? This is his interpretation of that material, isn't it?
Yeah, I wrestled with that, and I wondered if he might have had a transcript of the hearing below, but I don't think he had, because I can't see him referring to it there, and I don't have, and have never seen a copy of the transcript of the hearing itself before Deputy District Judge Pithouse. I've only ever seen the transcript of the judgment we've been looking at. So I think it's safe for us to assume that what we see here
Well,
is
can
what
we
is on
bottom
Judge
out
Parker.
whether there is somewhere lurking a transcript of the deputy's hearing?
My lord, I haven't seen a copy of the transcript.
I mean, it would be, I mean, I'm not asking that a transcript should be provided or produced, because it would be quite difficult in circumstances where the appeal judge had not had a transcript of the hearing that we should suddenly have it. And it was only because I wanted to check that, so far as counsel's current state of knowledge is concerned, there wasn't a transcript of the hearing itself, there was a transcript of the judgment, and that's the basis upon which we've so far been acting.
My lord, I think that when a transcript was called out for, the judgment was what we received.
Good. Well,
That's very much my
I'm
understanding.
not anxious to disturb that situation. I just wanted to make sure that I wasn't under a misunderstanding.
And we do, I think, we have the transcript of the hearing before Judge Parker,
Yes.
and there's no reference in that
No.
to any transcript of the hearing before the Deputy District Judge, is that right?
That is right, and for what it's worth, although I wasn't involved in the hearing in the court below, I did prepare the grounds for that, and I requested at that point, do we have a transcript of the actual hearing? And I was told the only transcript we have received thus far is of the judgment. So I think it's safe for us to assume that His Honour Judge Parker was looking at what we have here today.
And the language he uses at paragraph 12 rather suggests that as well, doesn't it?
Yes, I think that's a safe assumption, my lord.
My lords, I don't mean to interrupt my learned friend. I've had it positively confirmed by those that instruct me that there isn't a transcript.
Thank you very much.
Just so we're all clear.
Thank you. So in terms of the lack of conviction overall, the claimant simply does not accept that there was a lack of conviction in front of Deputy District Judge Pithouse to amend. You have the clear wording of Mr. Rowley's skeleton argument we've referred to. You have a detailed explanation as to how Mr. Rowley proposes this will be done. It's not woolly in the sense that Mr. Rowley's saying, goodness gracious me, I've only just identified this. I haven't a clue what we should do here, but I promise that I'll go away and think about it. He's saying, I've thought about it, I've identified what it is, and I shall do this. And should you be in any doubt, by all means, set me a date by which I should do it. Otherwise, my claim will be struck out. So I hope that deals with the assertion that the claimant's not positively saying they'll amend their pleading and that there's a lack of conviction in doing so. His Honour Judge Parker's decision makes clear findings of fact that the claimant is intending to amend their pleadings. And the question for us today, of course, is was he plainly wrong to come to that conclusion? And in the respondent's humble submission, that's a very difficult point for this court to arrive at, having seen...
Is that right? Isn't the first question, under ground one, whether the Deputy District Judge was wrong in his paragraph 10 to say that he was surprised because equivocation or lack of conviction? I'm paraphrasing. But...
Yes, I think that is the correct order. Any consideration of His Honour Judge Parker's case management decision, as it was, necessarily involves looking back to Deputy District Judge Pithouse's. But if I may, I will come to what Deputy District Judge Pithouse says in his judgment, and in summary, what the respondent submits is that it's not clear that he's saying, I've looked at all of this, I've made a balancing exercise, and it's not clear to me that the proposed amendment would work. What the respondent says and joins issue with His Honour Judge Parker as to this, that it's very unclear as to what exercise, balancing exercise, if any, has been taken in line with the exercise suggested in Sue Kim.
Well, your point, as I understand it, and I don't want to lengthen it if it's not necessary, is that paragraphs 17 and 18 of counsel's submission to the Deputy District Judge, in the first paragraph set out what the legal position was, and in the second paragraph clearly indicated an intention to put it right, to the extent that it was saying that you can put us under terms of an unless order to do so, and to read paragraph 18, which politely says that the claimant can make the amendments above, as being something short of a commitment, would be unreal.
unreal, at the very best grasping at semantics, i.e. the difference between can make and I jolly well will make.
Yes, I mean, but let's suppose the district judge considered that in the light of what had been going on up to this point, he had any doubt about whether they were actually going to do it, it would have been incumbent upon the court to say, well, when you say you might make an amendment, are you going to make an amendment? And if then he had any doubt, his next step would be to say, well, you're going to be struck out if you don't.
Quite so.
So is that your argument on this? And that the district judge's treatment of your paragraphs 17 and 18 was inadequate, and that without taking those matters into account, he was unable to reach a sound decision on the strikeout.
Quite so, my lord. In fact, I might gently go slightly further and say that the learned Deputy District Judge's treatment of paragraph 17 and 18 was almost wholly absent. There was no engagement with the suggestion, A, that we're going to make it. Deputy District Judge Pithouse does not say, well, I see in 17 and 18 you say you can make it, but you've not said you will. I have no faith that you will for the following reasons. And then the point taken by my learned friend, which I will expand on in due course if I may, there's nothing in his judgment where he says, well, this is all well and good, but you've not set out the actual specific part of the Polish civil code you rely upon. And so I find that's fatal to my belief that you can amend it. I mean, lent very heavily on today by the appellant, and I don't criticise my learned friend for the manner in which he emphasises that in front of you today, but that's not what was said in front of Deputy District Judge Pithouse, and it's not what was said, as far as I can divine, in front of His Honour Judge Parker. Perhaps that would be a convenient point for me to move on to making some brief submissions about the fact.
Before you do it, as I understand it, you simply say that the Deputy District Judge was wrong in paragraph 10. Say that the position was, and it was a matter of surprise to him, the claimants were merely considering whether they ought to apply to the court to amend.
Yes, insofar as
that you say was an error, which was obviously part of his reasoning, which would itself, amongst other things, have justified Judge Parker in interfering.
Yes, I say that particularly given the content of Mr. Rowley's skeleton argument, and particularly given that Mr. Rowley's inviting the court, well, set me a deadline for this, give me an unless order.
I understand.
The main plank of my learned friend's submissions today regards this lack of particularisation of the part of the Polish law code which would allow Miss Alton to pursue her claim should she remedy the defect in her pleadings. In essence, what the respondent submits about this is that the level of particularisation, the perfected pleadings, if you will, that my learned friend says is necessary, that's an incorrect reading of the law, and it's an incorrect reading of the test and the wording.
Your threshold point about this is that the emphasis that's being given to this issue now is not mirrored in the presentations that the other courts received.
No, wholly absent. And it goes further than that, my lord, if I may. At the very start of all of this, there's Miss Alton driving her car on a motorway. She's an innocent victim of this. She presents her claim to what has always been a Polish insurer. And she says to the Polish insurer, look, this is not right. You crashed into me. I've suffered a very modest loss. Will you compensate me for this? At no point do they write back and say, aha, no, I'm not liable for that. I'm not liable for that. Because unbeknownst to you, in Poland, there's no direct right, and we didn't adhere to these various EU directives. Bad luck. And it's absurd to propose that they wouldn't know that. They are a Polish insurer. That's all they do, is insure Polish vehicles in relation to road traffic matters. So not only has the point never been made in argument before, it's not a feature of this case overall. The way that the appellant puts his case today is, in essence, holding up a false defence. There's never been, and there could never be, it's not being said by my learned friend, well, there might be this defence, there is this defence, and it's never been said previously, it's never been argued previously. The issue for Deputy Deputy District Judge Pithouse and His Honour Judge Parker was there reasonable cause to believe? I join issue with my lords in terms of the very low bar of that, akin to the summary judgment strikeout test. So is it more than merely fanciful that you have reason to believe there's a direct cause of action in the manner suggested by Mr. Rowley in his skeleton argument against the Polish lorry? And I do think it's a germane consideration for both judges as to, well, what is the defendant saying about this? The defendant isn't saying, oh, well, no, that's not true. The defendant isn't saying that's not right. The defendant isn't saying that doesn't apply at all, you've got the wrong end of the stick. The claimant says, I think this is how it works. And it's fairly detailed. I respectfully disagree with my learned friend that paragraph 17 and 18 are, in Mr. Rowley's skeleton argument, 9th of March 22, are woolly. He sets out at 17a, this is the overarching law, how it operates. But then crucially at paragraph B, he says, and this is why that will work here. Poland is an EU member state. It's bound by the terms of the Sixth Monetary Insurance Directive. Pursuant to Article 18, each member state is required to permit a direct right of action. The overwhelming likelihood is that the law of Poland permits direct actions against liability insurers in the circumstances of this accident. Pause there, at which point the judge turns to the defendant. You have an opportunity. Would you like to say that that's not true? None of the previous hearings do they stand up and say either, well, that's not true. Poland is the exception to all of the other EU countries. Polish motorists can drive around Europe, collide with people with impunity, and there's no consequence. But neither do they say, oh, well, I'm holding my cards close to my chest here. That's for you to prove. You tell me how that works. They don't say that pre-litigation, they don't say that in front of Pithouse, and they don't say that in front of Parker. But in any event, what the respondent respectfully submits today is that when we bear in mind the low threshold test, i.e. a more than merely fanciful reason to believe that there's a direct action against Poland, Deputy District Judge Pithouse had ample material in front of him to come to the conclusion that the claimant should be allowed an argument at that, because that's all we're saying here. We're not saying we should allow the amendment, we're saying we should allow the opportunity to have the argument to maybe get the amendment, or maybe not. Why did Deputy District Judge Pithouse have all of the material? Well, firstly, it has the argument from Mr. Rowley, saying, well, this is how it works in general, and this is why it works in particular with Poland. Secondly, you have nothing from the defendant saying that's wrong, and here's for why. And then thirdly, it's on the balance of probabilities. It's the inherent likelihood of the circumstances, as put forward by Mr. Rowley in his statement. What's more likely? That Poland, as a member state who signed up to this directive for many years, just like every other member state, there's a direct right to sue their vehicles if they cause injury in the UK, or the alternative, that HGVs from Poland can drive around Europe, collide with, seriously injure, maim or kill people in those countries, and there is no facility to do so. Even absent the particular route map set out by Mr. Rowley, Pithouse and His Honour Judge Parker can take judicial notice of the likelihood that there's a more than fanciful prospect of the claimant being able to argue that there's a direct right of action in the manner set out by Mr. Rowley. So in terms of whether foreign law is a fact, the respondent doesn't disagree with the way my learned friend sets out that argument. We have to accept that foreign law is a fact because it is. But in terms of how that feature fits with the review we're making of this decision, the respondent respectfully disagrees that at the hearing in front of Deputy District Judge Pithouse, the claimant had to come with essentially a perfected pleading and say, well, this is everything, chapter and verse, including the Polish part of the law that's engaged that put this directive into place. The respondent certainly disagrees with the submission that we should have to, presumably before the pleadings have even been made in this case, turn up with expert evidence as to how the nature of foreign law operates in this fashion. And with respect draws attention to the fact this is a fast-track claim, which limits expert evidence, it be on a fixed cost basis, there'd be no provision for that expert evidence. So it can't be the fact that the CPR envisages that's how things should be, because the CPR says, well, you're not allowed to get expert evidence willy-nilly.
The CPR requires the parties to help the court to further the overriding objective. And so in a case where one party is, as it were, a specialist occupant of the terrain and another party is just a one-off visitor, I suppose it might be said that that bears upon how one should approach a situation where the specialist says to the ignorant party, you tell me.
I think there's force for the fact that parties, particularly in instances like this where liability for the accident itself isn't in dispute, I think there's a lot of force for the fact that the parties should cooperate in terms of, well, what's the correct course of action? What's how do you bring that claim against me?
I'm not suggesting necessarily there's a duty to teach people,
No.
But it would be a factor that might be taken into account in deciding whether to bring the whole proceeding to an end.
But in terms of whether, as I understood my learned friend's submission at its height, what he was saying is that Deputy District Judge Pithouse would have to be furnished with expert evidence on the facts of how Polish law operates, such that he could be content that the claimant had a more than fanciful prospect of arguing for the amendment to cure her pleadings. And in terms of that submission, the respondent rejects that. And one of the reasons why the respondent rejects that is the respondent points out that in a fast-track fixed cost case, there is no provision for that expert evidence. And if it was the case that the Rules Committee agreed with my learned friend's analysis, one of the fixed recoverable disbursements would be, in any foreign case, an expert's report setting out the factual nature of the law relied upon. But it's not, and the reason it's not is because that's not what's necessary to prove the fact of foreign law. I join issue with my lordship's observation that it's a technicality in terms of how we change the pleading. That's not to say it's not an important and necessary amendment in the pleading, and that's not to say that the foreign law itself is not a fact. But if I may put it like this, it's very much a fact with a small f. It's not a fact whereby we're saying we need to change where this accident happened, who was involved with it, the mechanism thereof, what injuries have been caused. It's simply a fact, if you wish, of clicking it from the person who we've erroneously pursued, using the same representatives, making the same factual case for the same injuries under a different cause of action. Now, that is a fact, but there must be a difference in my respectful submission and the respondent's respectful submission between changing a fact of law, if you will, like that, and between making a wholesale factual change about the case which you're putting. So in summary, the respondent agrees that foreign law as a matter of principle is a fact, but disagrees that the information in front of Deputy District Judge Pithouse had to be to the extent of expert evidence on a particular part of the code, or even a skeleton argument or a pleading from Mr. Rowley saying, here's how the law works in general, here's why I say it works, is likely to work in front as against the Polish tortfeasor. And here's the particular part of the code which shows that. The respondent says we didn't have to go that far. All we had to show is that on the balance of probabilities, there's reason to believe is more than merely arguable. We could correct that pleading. And it is telling to note, and I hope I've made the point, that the argument as advanced today wasn't put forward previous two hearings. And at no point, even today, is the defendant saying, oh, well, actually, it doesn't work like that. Actually, we're not liable to there is a technical deficiency in the amendment you propose. As it turns out, I was right all along, because you failed to put forward this particular part of the Polish code, your claim would never have succeeded. So we proceed almost, not quite, but almost on a mirage. The defence, the problem, the mischief which the appellant defendant puts before you today isn't one which is a real problem for the
I-
proposed
I-
defendant.
I may have misunderstood what you were saying a moment ago, but I was slightly surprised to hear you disagree with what had come from the appellant, which was an acceptance that the defect in the pleading was a technical defect. I appreciate that questions of foreign law and so forth are maybe were foundational, but I think what I'd understood by that concession was that it wasn't being suggested that it was one that was likely to be create a substantial difficulty if it was approached in the right way.
Yes,
It was only a matter of doing it. It wasn't a matter of whether it could be done.
yes, that's my understanding of that.
Yeah. So what was your difficulty with the description of the defect in your pleading as being a technical difficulty?
No difficulty with that description whatsoever. It is a technical defect, and I seek to draw the distinction between that type of technical alteration pleading and a wholesale changing of the facts. Or
Yes, I see. Well, I may have misunderstood what you were saying. I've got that.
So drawing back from the
Oh, sorry. It may not be a matter for consideration of the strikeout merits, but it was raised before the judge, and he discusses it. CPR 17.4 and the ability to amend where there's a limitation act point, substantially the same facts. As I understand it, what you're saying to the court is that the issue here is partly law, partly fact. And the reason why you say that is the directive is part of domestic law, and it's retained law, whatever, assimilated law. The bit which relates to foreign law is purely any provision in Poland complying with the directive. Have I understood correctly?
yes, that is.
I think the judge actually says that, but I just want to be clear.
And whilst we're on the issue of the application of 17.4, the principal complaint of the appellant today is that His Honour Judge Parker hasn't drawn in issues which go against any proposed amendment. In particular, it seems to be being said, well, there's an inordinate delay here in making this application. That should go against it. And that causes prejudice to other court users, and there's a general prejudice for not following court orders, not pleading things properly in the first place. All those might well be valid points, but they are, of course, subsumed in the subsequent hearing, if you will. Should His Honour Judge Parker, as he has done, say, well, I'm not going to strike it out, but he does that then does not then go on to say I automatically allow this amendment. It's listed for a further application, and at that application, I have no doubt that the appellant defendant will say, well, listen, here's something which goes against allowing this. 17.4 expressly provides that this is a consideration. You shouldn't allow this. This has gone on too long. Even if under 17.4 the court comes to the primary consideration, well, the first part of that test allows for this amendment. The right itself is then qualified. It's a double discretionary power. The court could still come to the conclusion. They could say, well, I think it's allowed, but because of the delay which the defendant points to here, although it would otherwise be allowable, I'm not going to exercise that discretion here. But what we're considering today is whether it was right to even let the claimant have that opportunity. And that's where we get into what His Honour Judge Parker has held in that regard, and whether we can say today, I say we, you of course, my lords, whether you can say that is wholly wrong, plainly wrong, whichever one of the various iterations of that test you wish to adopt. And it's there that I move to my skeleton argument, where I focus in on the findings of His Honour Judge Parker. Paragraph 3 of my skeleton argument.
Just before you do so, could I just ask you, in relation to the previous submissions you're making about the ability to cure the defective pleading, whether you place any reliance on what was said, particularly reflected in page 154 before the litigation was commenced. 154, we've got Ms. Alston's representative at NDW Law saying to Eleanor Carter at DAC Beechcroft, I note that you've requested in your defence court strikes out the claim in light of the defendant's name. We sent a letter of claim to Into Europe 16th September, in which we requested the details of the insurance company were sent across for our file. Your client responded, claiming, quotes, liability won't be an issue in the matter, close quotes. And then there are some points made about why it was suggested it was reasonable to assume that Into Europe was the insurer. And then penultimate paragraph, hoping that given liability is admitted, we can resolve this matter amicably, especially given that your client confirmed they were happy to settle the matter back in January. We already sent you an offer. And then, so far as one can see, the response to that is at page 159 from Ms. Carter at DAC Beechcroft, who says, in relation to the incorrect defendant, you haven't made any formal request to request the relevant insurer. You were aware from the previous correspondence that Into Europe was a claims handling company. He said even if you wish to amend the pleadings as to the correct defendant, there's an issue as to the fact that primary limitation has expired, and you've also incorrectly pleaded the cause of action against the defendant. Our client shouldn't be liable for any costs incurred in you remedying pleadings, which you've brought defectively. To the contrary, in the event that steps are taken to remedy those defects, our client will be seeking its costs of attending to them. From which it might be said that both the previous acceptance that liability wouldn't be an issue and the response that it was essentially a question of paying the wasted costs for remedying pleadings that could be defended were themselves indications which might be reliable that the defect in the pleading could be remedied.
Yes, I would join issue with that, and I hope I made clear in my previous, my prior
So you
submission.
join issue with that, or you would adopt that?
I would adopt that.
You wouldn't
analysis.
join issue with it. Sorry. Misheard you.
No, sorry, I wouldn't join issue. I'd adopt that analysis, and I'd also hope that my prior submission made clear that although today, and I don't criticise my learned friend at all for doing so, but although today the appellant's point is, well, how are we to know that these could ever be reasonably amended? You've not spelt that out, and you needed to do so. That's not a point that's been made previously, and in fact, I say all the way back to the start of the litigation, it's very much the contrary. What they're saying is, I will compensate you for this. Liability won't be an issue, but they are right to, and well within their rights, to point out that the manner in which the claim has been brought is incorrect. And as I hope I've made clear, the general tenor of my submissions is not that the claimant should be given carte blanche to simply proceed, but that they should have the chance, the opportunity to make that argument, because that argument is more than merely arguable.
On a completely separate matter, I see that the special damages in this case are said to be between £4,500 and £5,000. Is there any open, I don't want to trespass into any privileged communication, has there been any open pleading of the value of the general damages?
Not openly. I can see the entire claim is limited to 13,500.
Is that a magic number in terms of thresholds, or is
No,
that...
I didn't think so. I assumed that had been the file handler had made a provisional valuation of the matter and issued it at that level, and then the issue fee is paid as a percentage of that level on this type of claim.
Right, so the claim has been valued at 4,500 to 5,000 special damages and about 8,000 or so for general damages.
That would appear.
There was some reference to a broken hand, for example.
I think on any view, my lord, it is a modest personal
Yes.
injury which limps into the fast track.
Were the medical reports served with the particulars of claim?
I would imagine so, but I can, if you excuse my back, my lord, I can check. Yes, they were.
Am I right in thinking that there's a requirement in the rules to do so?
Yes, that's right. Unless obviously.
So the insurers would have had the medical reports on which the claim for general damages was premised.
Yes, yeah.
Thank you.
So if I could turn briefly to speak to my skeleton argument as to the particular objections the appellant makes of His Honour Judge Parker's findings. In terms of my skeleton argument, at paragraph 4, I make the point that my learned friend's skeleton argument identifies two main points: fail to attach any sufficient weight to the fact that I had already taken up time in pursuing an application, fail to consider or attach any sufficient weight to the fact on material before Deputy District Judge Pithouse there was no explanation as to why an application hadn't been made prior. In terms of the overarching submission such as it's pursued today, that there's a failure to attach any weight or make any consideration, as I say at paragraph 8 of my skeleton argument on the second page, that's unsustainable. It's clear that His Honour Judge Parker has considered these matters. I think properly put, what the appellant is saying is that he's placed undue weight on factors which he shouldn't have considered, and not enough weight on factors which he should have. I deal with that further at paragraph 10 of my skeleton argument. The appellant submits that His Honour Judge Parker should have found that R had been on notice of the defect in pleading as it related to the cause of action since the service of the defence. In terms of saying His Honour Judge Parker was plainly wrong about that, that's difficult in the respondent's submission for this court to find today, because at paragraph 3 of his judgment, His Honour Judge Parker addresses that head on. He says the defence spelt out in some detail that neither Inter-Europe nor PZU could be liable under the 2002 regulations. And so he has clearly in mind and has clearly said specifically, this is when you've been on notice on this. And so that's why I conclude at paragraph 12 that the argument's unsustainable on the evidence before you. There's also an analysis by His Honour Judge Parker of the extent of that delay. And the respondent submits that at paragraphs 30 to 33 of his judgment, he deals with that delay, the competing prejudice to each party. And in terms of whether that's clearly wrong, that's simply not a finding we can make today. In effect, what the respondent's saying is that his analysis is unimpeachable in that regard. Contrast that to the balancing act of Deputy District Judge Pithouse, wholly absent in terms of the competing balance of prejudice to each party, save for the opening part of the first paragraph where he makes the general point that it's always is slow to deprive any party of a valid cause of action. There's no particular part of that judgment where he says, well, on the one hand this, but on the other hand that. And in those circumstances, His Honour Judge Parker is right to disturb that prior finding and put in place his own. And my learned friend references paragraph 10 of Deputy District Judge Pithouse's judgment, where he says, I'm surprised we find ourselves in this situation 2 months hence. But His Honour Judge Parker correctly identifies in his judgment that there's no balancing of the prejudice towards the parties caused by that, and there's no real analysis of what the case of Sue Kim is saying should be the norm, i.e. the right for the party to have a chance to rectify their pleading. It's of note in the respondent's submission that there's no reference made to Sue Kim in Deputy District Judge Pithouse's decision. But it was clearly put to him, both orally by Mr. Rowley and in his skeleton argument. In terms of the paragraph 21 of their skeleton argument, the appellant concludes that His Honour Judge Parker erred in law because in finding that Deputy District Pithouse was wrong to strike out the claim because he did not have regard to the previous opportunities afforded to R and the lack of conviction in seeking to further amend the claim and the lengthy delay. I've already dealt with the factual, my factual submissions in regard to the lack of conviction. But in terms of how His Honour Judge Parker deals with that, I set out the respondent's argument at paragraph 21. As I've already stated, His Honour Judge Parker does go through the previous opportunities afforded. He starts that at paragraph 30, and the analysis continues to paragraph 37, where he concludes, I accept that there has been a long time in which they, presumably, claimant could have put matters right. However, if I compare this case with the underlying facts of Kim and Park, it's clear there that His Honour Judge Parker is dealing with the previous opportunities. To say he's not dealt with it at all can't be right. And is he clearly wrong when he makes that balancing act, when he considers Sue Kim and he considers the lengthy delay? The respondent submits not, and echoes again, at the risk of repetition, that the appellant defendant will have the opportunity at any subsequent application to make these points, to bring their complaint as to the passing of time in terms of any 17.4 application. For paragraph 23 on page 5 of my skeleton argument, I make the point I've already made, and that indeed is also made by His Honour Judge Parker in his judgment, that there is nowhere in Deputy District Judge Pithouse's brief judgment where these matters are considered and the balance of the prejudice, to each party is weighed as it should be. And His Honour Judge Parker is right to come to the conclusion, which is shot through his judgment, that it's difficult to see what Deputy District Pithouse is concluding, or is the ultimate balancing act that he's exercising, and what conclusion he's come to. It seems to be that he's saying, I do not think there is sufficient evidence before me to show that on the balance of probabilities, the claimant has a more than merely arguable chance to rectify this pleading, but it's very unclear how he comes to that conclusion. And I've already addressed you as to why, factually, that was incorrect in any event, and it follows that if you're with me on that, His Honour Judge Parker was right to overturn the decision of the Deputy District Judge. In terms of the second ground of appeal, unless I can assist further on the first ground of appeal.
No, thank you.
In terms of the second ground of appeal, I am more minded to submit that the second ground of appeal is almost the other side of the coin of the first side of the appeal, in that if your lordships are of the view that His Honour Judge Parker was correct in his analysis of Deputy District Judge Pithouse's decision, in that it was plainly wrong, there's no analysis of Sue Kim, there is ample information before him to come to the conclusion that there was a real conviction to amend those pleadings, the in less order, etc. And the claimant didn't have to go so far as to adduce expert evidence as to the fact of that foreign law, or invoke the particular part of the Polish code which would do so, i.e. there was more than enough for him to conclude on the balance of probabilities that there was an arguable prospect of remedying that defect. The respondent does submit that it flows axiomatically.
So the reasons why the Deputy District Judge was wrong can be repurposed to show why the judge's decision was within his range of reasonable decisions.
One is the corollary of the other, and insofar as the skeleton argument of my learned friend says that His Honour Judge Parker has erred in allowing this process without a formal application, without a formal amendment. The respondent says, well, that's not what His Honour Judge Parker has done. His Honour Judge Parker has said, I will allow you in the future to make the formal amendment. He's not said, he's not put that factor into his decision to not strike out the claim to overturn Deputy District Judge Pithouse, he simply said, well, I find you were wrong to strike out the claim, and you've seen the consequential order he gives. The final area that I'd address in general, perhaps, is shot through the appellant's skeleton argument and the oral submissions you've heard today, is an indication that the test from Sue Kim itself is perhaps, and the way that His Honour Judge Parker's approached that is perhaps not consistent with, if you want, a post-Jackson, post-Denton manner in which we deal with civil applications, relief from sanctions, and the like. The fact that His Honour Judge Parker, though, is saying, I'll allow this to go to a further application, means that all of those considerations, which are very much germane to such applications in the civil context now, delay, prejudice to other parties, use of court's resources, all of those will be considered at that hearing, and all of the complaints that the defendant makes about those, they can bring at that hearing. So it's not the fact that His Honour Judge Parker's order runs against that grain or goes against that general consideration. And there's nothing in his judgment which can be said to be wrong in that regard. The very final submission I'd make is one which echoes perhaps the starting observations made by your lordships and some of the observations made during the course of my learned friend's well-made submissions. If we take a step back here, Miss Alton is an innocent victim of a foreign tortfeasor. The first position, as a matter of common sense and natural justice, may I go so far as to say, would be she should be able to at least seek compensation from that tortfeasor. Although the defendant today says the manner in which the claimant's gone about this is wholly improper, and in fact, by your ruling today, she should be prevented from doing so, it's telling in the respondent's submission that it's throughout the hearings in front of Deputy District Judge Pithouse, His Honour Judge Parker, and indeed today, it's very hard for the defendant to identify an overt prejudice that would be caused to them by this. It's not the type of case where they're saying, and here's for why my evidence has gone stale, or I've lost my witness, or I can no longer investigate this aspect of causation. It's more of a case, what the defendant is saying is, well, you made a pig's ear of that, and I'm going to take full advantage of that. And the respondent respectfully urges this court to take a step back from the litigation in general, see that Miss Alton is the innocent tortfeasor, and in line with the dicta from Sue Kim, should be allowed at least the opportunity to present that application to perfect her pleading so that she can pursue her claim for compensation from the tortfeasor. Because if she's put in the other situation, it may well be said, and indeed I think it was said in the lower hearings by not my learned friend, but the previous barrister who represented the defendant, well, she has a cast iron claim against those who instruct me and those who she instructed. That certainly is a consideration, but any such claim is generally lower than the claim against a straight tortfeasor because it's a loss of a chance claim. And there's also the fact she'd have to find funding for that claim, pay a percentage of that claim by a CFA, probably furnish herself with an additional ATE product, and there's time, there's delay. All of these things mitigate against this type of satellite litigation, which isn't beneficial. So for all those reasons, the respondent respectfully asks the appeal is dismissed, unless there's any particular aspect I can assist you upon.
Thank you very much indeed, Mr. Patience. Yes, Mr. Krumer, any reply?
My lord, short responses. In terms of the submission made by my learned friends that one would never recover the cost of foreign law evidence in a fast track claim, that's entirely disabused by Rule 45.59b. My lord,
45 point.
sorry, my lord, 45.59 small b.
Thank you.
My lords, that's a general sweep-up rule that effectively allows any disbursement that's and this is the wording that the rule uses, reasonably incurred. If you've got to prove your case on foreign law or establish that you have the right to a cause of action under foreign law, and it's got to follow, in my respectful submission, that that's reasonably incurred. So that argument deployed by the claimant doesn't assist. Can I also say this, my lords? It's rather been assumed that the only claim that this claimant, the respondent, has is as against the appellant. It would have been entirely open to the claimant respondent to have brought proceedings against the tortfeasor directly. That's not shut out. What has happened is her...
You mean the lorry driver?
The lorry driver. The lorry driver. What has happened is that those that instruct my learned friend have taken the view, or the prior solicitors have taken the view, that they want to pursue the insurer directly. And my submission, for all the reasons that I've given, and I won't rehearse, is that if they're going to do that, then they jolly well have to do it properly. And you know what I say about that. My lords, with respect, I differ from my learned friend regarding the impact of foreign law. And I take you, if I may, to page 54 of the authorities bundle. This is the case of Bumper Corporation and the Commissioner of the Police of the Metropole, the decision of this court. My lords, you see there, around a third of the way down the page, there's a heading, Proof of Foreign Law. There's an issue that needed to be determined by the trial judge in that case, Mr. Justice Ian Kennedy, relating to Hindu law. In the second paragraph, it's set out that it's trite law that foreign law in our courts is treated as a question of fact. So far, so good. But if you continue to read the balance of that section that purports to deal with proof of foreign law, you see quickly that the court won't use its own researchers as to foreign law. Foreign law being a matter to be proved by expert evidence. So, my lords, I maintain wholly my submission that at the very least, the text of the Polish provision, whether it's the civil code relied upon by the respondent or another provision of Polish law, should be set out. And my lords, I think you have the point.
Can I just understand the extent to which there are different points you're making about identifying the relevant Polish law and proving it by expert evidence? I think I'm right in saying, but tell me if I'm wrong, that one of the exceptions to the need to prove foreign law as a question of fact is where it's admitted. And that's what one would expect to be the case.
Yes, my lord.
So if it were set out in the pleading and it were admitted, expert evidence wouldn't come into it at all, would it?
It wouldn't, my lord. But
So why are we concerned with the question of expert evidence at the stage we're at, which is a pleading stage?
well, my lord, it goes back to the point about having to set out your case by reference to the specific.
I understand the point you make that they needed to identify the particular provision of Polish law. What I wasn't quite following is quite where expert evidence comes into it, given the stage that we were at,
My lord,
which is can the pleading, the defective pleading, be cured as a pleading?
my lord, I say that that's the only proper material that the court can have regard to when reaching a determination as to whether the court possesses or has reason to believe using paragraph 40.
So are you saying that the district judge could not properly have concluded that the defect could be cured unless he had both identification of the relevant Polish provision and expert evidence before him that that was what Polish law provided. Is that your submission?
My lord, that's the highest that I put my submission. I say at the lowest, there needed to be identification of the Polish provision and at least some indication of what that Polish provision was to the judge for him to have that material upon which to reach his belief.
What was necessary was identification. Question of proof by expert evidence is not on analysis required at this pleading stage.
I thought that was what you were saying, at the highest.
Yes,
But not at the lowest.
Yes, at the high, because that otherwise it would be completely pointless to get expert evidence until one knew what the opponent was going to say about your pleading, would it not?
Well, my
And
lord,
that's what Bumper is telling us, that it's only when you have a conflict that you get the expert evidence. You wouldn't get it just as a nice to have.
my lord, given that foreign law is a matter of fact, any competent litigator in this jurisdiction, in my submission, would need, if they are going to plead foreign laws, going to have a helping hand from a foreign expert, else they run the risk.
In cases where your clients run into people, that's going to be expensive for you.
And entirely unnecessary if it turns out to be admitted.
They run the risk of pleading facts that are not correct. That's the risk.
Yes, but this is not a conversation that takes place in a vacuum. But had they approached this correctly, they would have asserted, and you would have responded, which is either, well, that's not an issue, or you've said you're wrong. At that point, people can start to take time and spend money on working out who's right about it. Isn't that the way that any reasonable system of justice would operate?
And my lord, the final point, and it follows on, there cannot, this court, in my respectful submission, would go too far by placing a burden on so-called specialist litigants to inform other litigants as to what the law is, or give them any kind of helping hand. If that be the case, then a foreign defendant
There's no obligation on anybody to help another party. It's a question of whether there's any obligation to help the court by taking a reasonable, proportionate approach to the issues that are raised in the litigation.
If that's the way that my lord puts the issue, then I see that. But to be plain, and I submit that the court should be very slow about placing that burden on any foreign defendant to correct or set straight any averment of foreign law, or indeed to overlook the absence of an averment of foreign law where it's needed to make a proper cause of action. My lords, unless I can assist you further.
No, thank you very much indeed. Well, can I thank both parties, those that support me, for the preparation of the appeal, and also for kindly allowing us to sit early, which has helped the court considerably on this particular occasion. Of course, we'll think about the arguments and let you have our decision and judgments as soon as we can. And they will, in the first instance, as you're aware, be in draft, which will be confidential to yourselves and your clients. Please observe the confidentiality rubric at the top of the draft judgments. We'll be grateful for any editorial or obvious errors being corrected within the timescale with which you'll be set, and for a draft order reflecting our decision. And the judgments will then be handed down in the normal way electronically. We won't need to trouble you to return for that. If there are any matters you can't agree, please give us short written submissions and we'll resolve them in writing.
Thank you, my
Thank you
lord.
very much indeed.
My lord, can I beg your pardon and ask whether you require paper copies of the skeleton argument that was sent to you?
That was it. It may or may not have arrived so far. If it hasn't, well then we'll make communication to make sure that we've picked it up. And I don't think it's likely that anything will arise once anything unforeseen will arise, but once we've read it, if it does, we'll give you both a chance to comment.
But electronically is fine. We can put it in paper form if we need it.
I'm grateful, my lord.
Or was that the point?
Is that your point?
It was, my lord.
Thank you very much.
Table.